Does a criminal defendant have the right to get an advance ruling on whether the prosecutor can cross-examine him about prior bad acts or crimes? To find out, you have to read People v. Sandoval, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a special limited series I'm doing on landmark cases from the New York Court of Appeals. This is the case of People v. Sandoval. The citation for this case is 34 New York 2nd 371, published by the New York Court of Appeals on June 19th of 1974. The issue in this case is whether the defendant has a right to an advance evidentiary ruling on the scope of cross-examination that will be allowed with respect to prior bad acts. I'll explain all that in a few moments. The background that's helpful to understand and appreciate the context of this case is that in a case, in a trial, a defendant has a fundamental right. The defendant is the only person that can decide whether the defendant wants to testify in his or her own behalf at trial. The lawyer can't decide that for the defendant. It's up to the defendant, him or herself, to decide that. But when a person testifies, when a defendant testifies, or any person, including the defendant, when a person testifies on their own behalf, they become subject to cross-examination. You're not allowed to just testify and say, this is what I think, or this is what I say, and I'm not going to answer any questions about it. One of the rules of an examination is that an examination is both direct examination and cross-examination. Unless you get the cross, you don't get to consider the direct. So if a defendant chooses to testify and put himself under oath and answer questions or answer questions from his own attorney on his own behalf, he has to be willing to answer questions on cross-examination, which makes it dangerous for a defendant because if a defendant doesn't know what's coming, they can't intelligently decide whether to testify or not. Okay, so what are the facts in this case? The facts are, this is a murder trial, and Mr. Sandoval is being accused of murder and charged with murder. Before jury selection, his lawyer, Mr. Sandoval's lawyer, makes a motion to the trial court requesting that the judge prohibit the use of certain parts of his rap sheet, certain parts of his criminal history with respect to impeaching the defendant if he chooses to testify. So he says, if I testify, I don't want the prosecutor to be able to ask me questions about my criminal history. The judge then conducts a hearing and rules that the ADA, the prosecutor, could cross-examine the defendant on a 1964 conviction for disorderly conduct, a 1965 conviction for assault 3, and inquire about the underlying facts. But the judge says the prosecutor is not allowed to cross-examine the defendant about a charge from 1960 about contributing to the delinquency of a minor, or a DWI from 63, or a DWI from 65, driving while intoxicated. Will not be allowed to cross-examine the defendant about a felonious assault arrest resulting in a dismissal, a traffic violation, or a gambling incident. The defendant is ultimately convicted and appeals, saying that this was improper. The appellate division affirms what the trial judge does, and it goes to the Court of Appeals. And here, this is a case where they agree. The Court of Appeals first holds that they agree with the appellate division that this was no abuse of discretion. That's the standard by which a judge is reviewed, whether the judge abused his or her discretion as a matter of law in deciding what to allow. But what they do say here is this is the quote, we now hold that in the exercise of that discretion, a trial judge may, as the trial judge did in this case, make an advance ruling as to the use by the prosecutor of prior convictions or proof of prior commission of specific criminal, vicious, or immoral acts for the purpose of impeaching a defendant's credibility. The Court of Appeals holds, and we now have what's called a Sandoval hearing because of this case. They say that the trial judge it's good for the trial judge to give advanced ruling about whether the defendant will be subject to cross-examination about certain prior bad acts, commission of criminal, vicious, or immoral acts. But in doing so, the judge has to consider the probative value of the examination, of the cross-examination, versus the risk of unfair prejudice to the defendant, which is measured in two different ways: the impact of the evidence if admitted to his testimony, and the effect that allowing that cross-examination would have in discouraging the defendant from taking the stand in his own behalf. they specifically indicate that that's a danger. A danger is if the judge allows cross-examination about certain things and the defendant says, well, if I'm going to be cross-examined about that, I'm not going to testify on my own behalf. That is prejudicial. That could impair the defendant's ability to have a free and fair trial. They say the vehicle to bring this to this is a long kind of case talking about the outlines of what this application is. They say the application here is a motion by the defendant. It's the defendant's motion, his burden, and the standard to consider whether it should be allowed is whether the prejudicial effect of impeachment testimony far outweighs the probative worth of the evidence on the issue of credibility. So it's not a 50-50. It's not, is this even to this? It's not even, is the prejudicial effect outweigh the probative value? It's does the prejudicial effect of the impeachment testimony far outweigh the probative worth of the evidence on the issue of credibility. And then they give a bunch of general rules here. They say that prior bad acts will always be detrimental to the defendant. The two questions about whether it destroys a fair trial is whether it has a disproportionate and improper impact on the trier of fact, and whether it undesirably deters the defendant from taking the stand when he is the only source of material. Like if the defendant's the only other witness other than the victim to the incident, keeping him off the stand, depriving the jury or the fact finder of his testimony is not good. They say that's prejudicial. Some other general rules to consider. The lapse of time affects materiality and relevance. So the farther away it is in the past, the less relevant it is, the less probative it is. Acts of impulsive violence, particularly if remote in time, seldom bear on the defendant's veracity or credibility. Crimes may be highly prejudicial and inadmissible when there's no other purpose to them other than to show the defendant is a criminal kind of a person, has a criminal bent or character. They say a crime that shows the defendant's willingness to put his own interest above that of society may bear on credibility. They say crimes of addiction or uncontrolled habit, like alcohol abuse or drug addiction, may have lesser probative value on veracity. They say crimes like perjury or theft or dishonesty or deceit or bribery, these crimes of trust, will usually have a very material relevance, whatever they were committed, even if they're 30, 40, 50 years in the past. Traffic violations should rarely, if ever, be allowed. And they say that when the prior act is very similar to the charged offense, then the risk of prejudice is increased. And because the jury might consider it as proof the defendant committed this charged offense. And ultimately, they say, once again, it's the defendant's burden to make this kind of a motion. And the trial judge has to then determine whether the defendant has met his burden to demonstrate that the prejudicial effect of the admission of the evidence for impeachment purposes so far outweighs the probative value as to warrant its exclusion. And that's the case of People versus Sandoval. And it's why we have Sandoval hearings now before almost every criminal trial. Thank you. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.